This is where the negotiation part comes in. So those 12 and 15-year terms that I got, I was able to negotiate the longer term, not by putting more money down, but they had an interest in allowing me to, because I went up to both these guys and I said, listen, the value of the house, my fear is that the value of the house is in 3 years at the end of the term, or 2 years won't be there for me to sell it, capture my money back, or refinance and move to get my money back. So I need you to give me more time. And in return, I'm going to continue to pay it, I'm going to take care of it, I'm going to do this, I'm going to do this, I'm going to do this. And that's how we get a 12 or a 13-year term, because I needed that much time. My sales pitch is, hey, listen, Darren, I'm looking at doing these agreements for sales, and you know the Alberta market, and he's not my lawyer, he's the seller, okay? Unless you want to do an agreement on your house. But hey, listen,
so it's got to be a win-win.
Yeah,
so he's got to make me win on this.
Well, no, it's true, but it's, hey, Darren, listen, I'd love to do an agreement for sale on this house, or I'd love to buy this house, but here's the strategy. It's an agreement for sale. Really quick, okay, I'm just making this up. It's an agreement for sale option. It's kind of like an assumable, but you're going to get what you want out of it. Unfortunately, I just need some time to get what I want out of it. You need to get out of it. You need your payments. You need to just walk away from this because of whatever the situation is. You want out. Okay, great. Listen, I'm going to make all the payments for you for the next 10 years, but I need 10 years. Oh, that's too long. That's too long. I need my money. I need off the title right now. Great, I get that. However, I can't buy it because I don't want to take on the risk.
Right.
I don't want to take on the risk that in 3 years house prices drop in Alberta, and all of a sudden now I'm stuck with this house that I can't sell it, because all I'm going to do there is give it back to you. I'm just going to walk away and say, here, take the property back, because he still owns it, right, legally.
Which is that mortgage issue, right? I mean,
totally.
Seller financing, if he just wants to walk away, he can walk away.
So then I say, to prevent this from happening, listen, I just need another 5 years. Give me 8 years. Let me buy down the debts enough that I can sell it and recoup my money. That's how you can get that longer extension.
Yeah. All right. So, because of all those kinds of issues and some of the risks, the agreement for sale is going to have to cover those, right? So, the buyer gets some protection. So, you weave into this agreement a few different things. So, number one, remember the buyer's paying money up front, but you don't have title. So, you want to protect yourself. What if the seller decides to sell it to his aunt or something else from under you? Well, you protect yourself by way of registering something on title. In Alberta, it's called caveat. It's just a notice to the whole world that you have an interest in that property. It's a beneficial interest pursuant to the agreement for sale.
But you sit second on because the mortgage would be first.
That's right. Oh yeah, you sit behind the mortgage, and whatever else happens to be on title could be could be a second mortgage, whatever. You're going to have to find out before you enter into an agreement for sale what title looks like, and a whole bunch of information which we can talk about. But basically, yeah, it doesn't matter. You still get something on title, so they can't sell it out from under you, because you're going to start making payments on it. You're going to take control. You want to know that nothing funky is going to happen to that property, to the title, to legal title. The second thing you might want to ask for, and that may not be given to you, is a power of attorney. A power of attorney is where the seller gives the buyer basically the power to deal with the property. This is very helpful when you walk into the bank, for example, and want to set up an account to pay the mortgage. If you've got a power of attorney, you can oftentimes get them to deal with you as if you were the owner, essentially. Right? That's what a power of attorney is.
Do you need originals for the power of attorney?
Sometimes you do, sometimes you don't. Yes. Yeah, we've come across this before. Land titles, if you're going to register the power of attorney against title to the land, it needs an original. Oftentimes other people don't. Some banks do, as Jared's learned, but most often a notarized true copy of that power of attorney should be sufficient for most people.
Does anyone understand what a POA, a power of attorney, will do? Does anyone not understand what it'll do? Good. Okay.
No? Good? Okay. All right, and then the last thing, which oftentimes isn't the case, unless you're putting a lot of money down, you're not going to get this, probably, from most sellers. It's to hold the actual transfer of land in trust. That's really good security. So the seller actually signs a transfer of land. It's held by me or your lawyer in trust until the deal's done and you're ready to transfer title at the end. That's really cool to have. Along with those other two, you're golden. The buyer's a lot better off than most buyers in the agreement for sale. So that's helpful. The seller, okay, is giving up possession and control, right? Possession is 9/10 of the law, whatever. You probably heard that. Well, yeah, that scares the living daylights out of a seller, right? You're giving away possession. You're also giving away control, because chances are the buyer's going to walk in there and start to deal with all your payees. They're going to start paying your taxes. They're going to talk to your bank. They're going to start paying mortgages, all that kind of fun stuff. So you need to be protected. Well, under the Law and Property Act, you have, if the guy defaults or walks away, as Jared says, well, you get the property back. You can foreclose. You can do all that kind of stuff. Remember, one of the big motivating factors for the seller is that as you're going to get whatever money is going to be paid, you're going to get it up front. So that's helpful. You're already paid what you're going to be paid, right? You're not going to get much, if anything, at the back end. You're getting it at the front end. So that's helpful. That protects the seller. Yeah.
Why can't you back end load it?
You can.
Like, why couldn't I do an agreement for sale and say, listen, instead of giving you 200 grand today,
yeah,
I'll give it to you. You know what? Now that I think about this, that's what I should have done.
Yeah. Sorry, man. You just screwed up.
No.
Deal? Oh.
But
yeah.
always learning lessons.
Yeah.
But why couldn't you back end load it?
You can.
You could even sweeten the pot.
Yeah.
A little bit to get that agreement for sale.
Yeah. Yeah, you can. And that works really well where the seller is in financial difficulty and just can't make payments, and where there's very little equity anyway. Mm-hmm. In fact, that's really what's going to happen. There's oftentimes agreement for sales or situations where the seller really isn't walking away with anything, and so essentially you are back ending. It's a way to get in as a buyer without paying hardly anything down, like almost zero.
Does that make sense? Back end load an agreement for sale?
Yeah.
Because now you can probably get a 10, 12, 15-year term if you back end load it.
Maybe. And the longer the term, the more hair you have on it if there's a mortgage on title. Mm-hmm. The mortgage, if it's a long-term mortgage, you got lots of term left, then you can line it up nicely. But then you're dealing with renewals. If you're going past 5 years, 10 years, yeah, 15 years, then you're dealing with renewals, and there's a chance that they could that could turn into.
You're telling me this right now?
Yeah.
No, totally.
Yeah.
I already knew that.
Yeah. No, and so circumstances change and rules change. You could have some issues there as the seller has to continually just renew. And oftentimes it's automatic, so it's not going to be a problem, but there is a small risk factor there.
I guess that all that, like Mona said, the smaller banks can call. So if you're doing an agreement for sale from somebody and they're dealing with a small bank, and that guy you're doing business with is going delinquent on files or on other payments, that Mona, maybe you can, because that person on an agreement for sale, he's holding the mortgage, but so let's say I do an agreement for sale on Darren's house. Yeah. I take the house from Darren, I assume the debt, but for the next 3 years, he's late on payments. Renewal comes due,
yeah,
and it's with a smaller bank. They could actually call that loan.
Yeah.
Although I've been making the mortgage payments for the last 3 years, he's not honoring his commitment. They call the loan.
For sure. So sorry, tell me, where's the safety net there?
Well, that's the risk.
Yeah, well, the safety net is in the administration process, which we'll get to. Is that a guy like Jared is going to make certain that his money is going towards the mortgage payment.
Yeah.
You're not going to let that happen. Yeah.
So Darren, you might know about this, but what I did with my group for sale that you're currently closing on
this is good, you guys.
A joint account.
Yeah.
And so.
So you what? Sorry, you
opened up a joint account.
We opened up a joint account, so all of that money that I pay in, I watch what he does. Like, he can't pull it out. Like, if he pulls it out, I will see it. It goes to anything except for the mortgage payment line of credit. Yeah. So isn't that a great way?
Beautiful.
That's a good idea.
That's a fantastic way. And we're going to get to that. I mean, the bottom line is, you are going to be in a relationship with an agreement for sale isn't as clean in the sense of, a standard deal, you do the deal, you never see them again, right? You may, in fact, if you use a realtor, you may never see the seller, ever. You may not know them from Adam. So, in an agreement for sale, that's not the case. You're going to be in relationship with these guys to some degree, especially at the front end when you set this all up. And one of the things you can do to alleviate some of the risk factor is to do what Jillian's talking about, is to coordinate together with the seller and make sure that the payees are getting paid. Yeah, question?
Just a quick question. What's the definition of a small bank?
Yeah, there's no such thing as a small bank. A bank is going to be funded, but because banks are big, mean, awful institutions that can destroy you, but they can also help you. And so if you get a good relationship with a bank, you're going to be in a good relationship no matter if it's one of the big six or one of the smaller ones. The issue that Jared's talking about is usually the subprime lenders, is what I call them, or the Eastern lenders, like MCAP was notorious. Like 2-3 years ago, they put the hammer down, and anybody that had an MCAP mortgage that was coming due in Alberta, they said, nope, refinance, and they gave notice to people, like 30, 60, 90 days before their maturity date, saying, just so you know, hey, we're not going to renew you, and people were scrambling to try to get refinanced.
I was one of them. I had a few of those.
Yeah. So there you go. So, it's hard to tell who exactly is doing that these days. But
so why did the big banks not do that? Is it just because there's so many accounts that they care?
Well, two reasons. Number one, they have a lot more insight into the Alberta market, and didn't run scared when they saw what was happening here. Because I think that's the difference between people that had boots on the ground and people that were actually living in the community and doing the work versus people that were just, brokers were sending them deals and they were making the assessments in Toronto. I think that was a big issue. And I think another factor too was their risk aversion because they were leveraged. The MCAPs of the world, I don't want to disparage any particular lender, they all help people get money that they wouldn't otherwise get. But I think they took on risk to a larger degree than the big six, and so they backed up quicker too. I think that was the big issue. Yeah. All right. Well, the big thing is, the seller's comfortable because they're retaining title. I mean, that's pretty awesome leverage for a seller as well. Okay. All right. So just a really quick example. Don't interrupt me.
No.
I'll lose. I'm not a math. I can't do math even the best of times. So if I get interrupted, I'm lost. Okay. So standard purchase. Just stay in this one column here. Just stay with me for a second. So on a standard purchase, if you have fair market value $300,000, don't worry about the current balance. I shouldn't have put that in there. That's not applicable either. When you're doing the deal, say you put a $10,000 deposit down, you're going to have a balance due roughly at closing of $290,000, right? Simple math. Very, very, very simple. So the seller's going to walk away with $10,000 because $290,000 is going to pay off his mortgage, and everybody's happy. $300,000 purchase price, $10,000 deposit, $290,000 off the bank. Okay? Mm-hmm. All right, with an agreement for sale, it's just a little bit different. And the two big pieces of the puzzle that you're going to need to know at the beginning of the process, before you sign off on the agreement for sale, is going to be the current mortgage balance and the balance at maturity of that mortgage. This is assuming the seller has a mortgage on title, and usually it is, okay, for agreements for sale. All right, so if you see how the deal plays out then, same that $10,000 deposit, same fair market value, the balance due at closing is $270,000. Why is that, do you think? Mortgage pay down, that's right, because remember, during that interim period, the buyer's stepping in, taking possession, and paying all the carrying costs, including the mortgage, principal, and interest payments. Principal and interest payments. So over the course of that agreement for sale, the buyer's paying down the seller's mortgage. Right? Mm-hmm. And so the mortgage is decreasing in value. And so the balance due at closing is going to be a smaller amount. So effectively, and not necessarily legally, your purchase price is $280, and you just spread out your purchase over a longer period of time. It's a cash flow benefit to the buyer, in essence. You don't have to come up with that money straight up. Right? The seller still walks away with the same money. So the seller's just as happy as in a normal deal.
Okay. And a lot of times, can I interrupt you?
Yeah. Now you can.
So a lot of times the seller, like what I find with agreement for sales, like I like agreement for sales a lot, and I just was trying to do a deal with Vinny on a house a few months back where the seller was pretty tight on the sale price. He needed $295 or $297 or something like that. And I came up with this idea of an agreement for sale. I'm like, let's just do an agreement for sale. I was going to renovate the house and sell it anyway, so I just said, let's just do an agreement for sale. I'll take over the debt. I'll pay out the $3,000 interest only for 3 payments to get out of the debt. I'll assume it. Agreement for sale, no money. I'm not paying 1 penny into this house. And Vinny went back and approached the seller on it. It got a little bit confusing because he wasn't understanding what was happening. In the end, I paid $297 to the house. and he ended up taking a $5,000 or $8,000 hit because he had to pay all his penalties and his taxes, and he had to pay all this stuff, because I was just gonna assume
Yeah.
the debt. So he couldn't understand the concept, I guess, of the agreement for sale.
Yeah.
You know, but in that example, there's lots of those examples out right now where there's a seller who needs to get X, and X is like break even. And now if you can come in and do that agreement for sale, a lot of times sellers just, you know, they might be in arrears,
Yeah.
$5,000, and you just gotta pay out that $5,000. But those are the conversations that
Yeah.
have to be had.
Yeah.
And when you use an agent, those are the conversations that he has to have with the selling agent, or get you into a room with them to have those conversations.
And it would be very helpful to be in the same room and describe it, or the seller has a lawyer that understands agreements for sale. Because it's very difficult to explain this concept to someone who hasn't actually done any of them or understood it.
Can we talk about that just for a second? Because I
Yeah.
think you just hit a huge nail on the head of lawyers. Not all lawyers understand or have done agreement for sales.
No.
Like there's lots that I've talked to. They're like, you know, they've never done one. They don't have the experience in it. They don't have the history of it, which means they can't go to bat for you, which is huge for me as the buyer.
Yeah.
But if the seller's lawyer doesn't understand it, that's an issue as well.
Yeah.
Yeah.
Maybe even a bigger one, because they a lot of times they'll actually counsel their client against it.
Yeah.
For some, you know, because there are risks there. I mean, if you just buy, if you just sell, you're out from under. You know, it's clean. It's what real estate lawyers do every day. So it's pretty inside the box, and there's not as much stress and question marks. But if you have an agreement for sale, it raises some question marks for someone who hasn't done it before. The other person who you want in your I guess in the know would be your mortgage lender, because at the end of this process, when the agreement for sale matures and you're going to close on the deal and actually pay the balance and acquire title, if you're using mortgage financing to do that, the bank wants to see, they always want the purchase agreement. And usually it's a standard real estate purchase contract that all the realtors fill out and give. And oftentimes an agreement for sale isn't something they can understand. And so you're sometimes running that on the back end.
But also, one more question. How would that look? So if 5 years from now these terms come due and I have an agreement for sale on a house.
Yeah.
And it's not a standard contract.
No.
You know, like all the agreement for sales, I don't have a contract.
Well, you have one, but it doesn't look like.
But it's not like a normal purchase contract where it's here you go, Mona, boom, 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 simple, right?
Yeah.
So how would the banks view that? Mona, maybe you can answer this question too. How would the banks view 5 years from now, here's the price? They'd obviously have to go with the house appraised, and it'd be financed based off of appraised value, I'm assuming.
Yeah.
Because there's no actual set purchase price.
Yeah, that's why I like to have an agreement for sale. It's nice if you have a nice summary, what I have, like a schedule, an addendum to it, that basically tells the story. So you got all the numbers, here's the actual purchase price, here's the mortgage balance, here's the balance that I'm going to have to pay at the end of on the maturity date, here's the maturity date. So the basic, you know, as long as the banker or the broker can understand a one-page addendum, they can understand the agreement.
Right. And the key is to make it very simple.
Very simple, very simple. So that is going to tell the story. The rest of it is legalese. It's a bunch of small print. So it's tough sometimes. The other alternative that I'm happy to do as the lawyer on the deal is if you've got a good relationship with the seller, and you would have, because you would have been in relationship with them this whole time and making sure payments are being made. Remember, you can get to that end game and you say, I'm running into problems with getting financing. I just can't get my bank to wrap their mind around this. You can at that point agree to essentially enter into a new standard form residential real estate purchase agreement that just reflects the exact same terms, the back end terms of the agreement for sale. That's legit. You're terminating one agreement, entering in another agreement. It's conditional on actual closing. So that keeps it clean. Banks will love it.
Can I ask you another question?
Yeah.
Oh, sorry, Carlos, go ahead.
Yeah.
Just really a question. Is an agreement for sale essentially the same thing as a lease option?
Okay, good question. There's rent-own, lease options. Those are other terms. Kind of. They are kind of like that. They can basically have